All rise. Vous vous levez. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning. The court is in session. Would the court officer please call the case?
Good morning. Situation in the Democratic Republic of the Congo in the case of the prosecutor versus Thomas Lubanga Dyilo, case reference ICC 0104-0106, and for the record, we are in open session.
Thank you very much. May I ask the parties to introduce themselves for the record, starting with the defense of Mr. Lubanga, please.
Monsieur le Président, la défense de Monsieur Lubanga est représentée par Jean-Marie Bijoux-Duval, Maître Caroline Buteau et Catherine Mabille, moi-même.
Merci, Madame. Could I then invite the legal representatives? First of all, I understand the legal representatives for victims VO1 are represented by the OBCV. So please go ahead.
Good morning, Mr. President, Your Honors. Victims in this proceeding are represented by 3 different group of legal representatives. I'm appearing today for the Office of Public Counsel for Victims. I am Paulina Massidda, Principal Counsel. Appearing with me today, Ms. Sara Pelé, Counsel, and Mr. Dimitro Suprun, Counsel. I'm also appearing today on behalf of a group of V01 by virtue of a power of attorney filed this morning in the record of a case. For the group of victims V01 is also present with me today in courtroom, Ms. Evelyn Ombeni, case manager. Thank you.
Thank you very much. Duly noted. And legal representatives of victim group 2, please, could you introduce yourself?
Oui, merci beaucoup pour la parole. C'est Maître Joseph Keta. Je représente l'équipe VO1 et VO2 plutôt, VO2, avec la case manager Sylviana Gloginon, qui est la gestionnaire des dossiers. Merci, Monsieur le Président.
Thank you very much. And Trust Fund for Victims. Sorry.
Morning, Mr. President, Your Honors. My name is Silke Stutzinski. I'm the legal advisor, and I come on behalf of the Trust Fund.
Thank you very much. I'm Erkki Korula, presiding judge in the final appeals proceedings in the case of Prosecutor versus Thomas Lubanga Dyilo. Seated directly to my right is Judge Song and then Judge Monaghan. And to my direct left, Judge Ushacka, and then next, Judge Trendafilova. Let me begin by saying that during today's summary, I will refer to the group of victims represented by the OBCV on behalf of the Monsieur Valain and Monsieur Mulenda as the legal representatives of victims VO1. And the other group represented by Mr. Babita and her colleagues as the legal representatives for victims VO2. I will refer to the Office of Public Counsel for Victims as the OBCV and Mr. Thomas Lubanga Dyilo as Mr. Lubanga. The Trust Fund for Victims will be referred to as the Trust Fund. Today, the Appeals Chamber is delivering its judgment on the appeals filed by Mr. Lubanga, the legal representatives of victims VO1 and the legal representatives of victims VO2, jointly with the OBCV against the decision of Trial Chamber 1 entitled Decision Establishing the Principles and Procedures to be Applied to Reparations. In this summary, I will refer to this decision as the impugned decision. Please note that only the written judgment is authoritative. It will be notified to the parties shortly after this hearing. On the 7th of August 2012, Trial Chamber 1 delivered the impugned decision. 4 appeals against the impugned decision were filed, 3 pursuant to Article 82.4 of the statute and 1 pursuant to Article 82.1d of the statute. On the 14th of December 2012, the Appeals Chamber rendered its decision on the admissibility of the appeals. The Appeals Chamber concluded that the appeals filed pursuant to Article 82.4 of the statute were admissible, whereas the appeal filed pursuant to Article 82.1d of the statute was inadmissible. In that same decision, the Appeals Chamber granted the request for suspensive effect of the impugned decision, partly due to the fact that Mr. Lubanga's appeal against his conviction was still pending at the time. On the 5th of February 2013, Mr. Lubanga, the legal representatives of victims VO1 and the legal representatives of victims VO2 jointly with the OBCV submitted their respective documents in support of their appeals against the impugned decision. Responses to the documents in support of the appeals were filed by the parties on the 7th and 8th of April 2013. On the 8th of April 2013, the same year, the Trust Fund, having been invited by the Appeals Chamber, filed observations on the appeals. Last year, on the 1st December 2014, the Appeals Chamber confirmed the conviction decision and sentencing decision in the Lubanga case, Judge Usatska dissenting and Judge Song partly dissenting the both decisions. The legal representatives of victims VO1, the OBCV, jointly with the legal representatives of victims VO2 and Mr. Lubanga alleges that the impugned decision is tainted by various errors. The Appeals Chamber recalls that in the admissibility decision it held that for the purposes of admissibility and without prejudice to a decision on the merits, the impugned decision could be appealed as an order for reparations under Article 75 of the statute. The Appeals Chamber did not find in that decision that the impugned decision was an order for reparations under Article of the statute based on its content and substance. In this respect, while the court's legal texts do not provide a definition as such, of an order for reparations, the appeals chamber considers that when read together, the court's legal texts provide a clear framework as to the minimum elements required for a decision to be an order for reparations pursuant to Article 75 of the statute. The appeals chamber considers that these elements, which I will elaborate upon shortly, are not only vital to the proper implementation of the order, but also ensure that in all cases when reparations are awarded, the court shall respect the rights of the victims and the convicted person as provided for in Rule 97, Para 3 of the Rules of Procedure and Evidence. The appeals chamber has reviewed the impugned decision in order to determine whether in its content and substance it contains an order for reparations within the meaning of Article 75 in light of the 5 minimum required elements. The appeals chamber recalls that Rule 153, Para 1, provides that the appeals chamber may confirm, reverse, and amend a reparations order made under Article 75. Having reviewed the impugned decision, the appeals chamber considers that its content and substance do not comply with the required minimum elements of an order for reparations. However, in the view of the appeals chamber, these deficiencies can be corrected pursuant to its amendment power under Article 153, Para 1. Accordingly, the appeals chamber holds that the impugned decision contains sufficient elements to be an order for reparations within the meaning of Article 75 of the statute, subject to the amendments detailed in the judgment that will soon be notified. I will now briefly address each element. Within each element, I will also address the grounds of appeal raised by the parties. The first required element of an order for reparations under the statute is that it must be directed against the convicted person. The appeals chamber considers that the trial chamber erred in interpreting the words "through the trust fund" as replacing, and I quote, "against the convicted person," unquote. The appeals chamber now holds that an order for reparations must always be against the convicted person and may, in addition, be made through the trust fund. The appeals chamber accordingly amends the impugned decision so that the order for reparations is against Mr. Lubanga. As a result of this amendment, the different standards of causation and proof established by the trial chamber, depending on whether the order was made against Mr. Lubanga or through the trust fund, are also amended by removing the standards the trial chamber established for orders for reparations made solely through the trust fund. Further, having amended the order so that it is against Mr. Lubanga, the arguments related to the status of Mr. Lubanga and the prosecutor as parties are dismissed as moot. The second element relates to the grounds of appeal regarding whether Mr. Lubanga should be held liable for any reparations awarded. The appeals chamber considers that an order for reparations must establish and inform the convicted person of his or her liability with respect to the reparations awarded in the order. In other words, the convicted person is the individual liable for any reparations awarded. Therefore, the appeals chamber considers that the trial chamber erred in considering that the circumstances of this case, specifically Mr. Lubanga's present state of indigence, meant that he is not personally liable for reparations ordered in this case. The trial chamber also erred in assuming control over the trust fund's other resources in order to fund the reparation awards. The trial chamber amends the impugned decision in line with the following holding. When a convicted person is unable to immediately comply with an order for reparations for reasons of indigence, the trust fund may advance its other resources, but such intervention does not exonerate the convicted person from liability. The convicted person remains liable and must reimburse the trust fund. Furthermore, the determination of whether to allocate the trust fund's other resources for purposes of complementing the resources available for the awards for reparations falls solely within the discretion of the trust fund's board of directors. The appeals chamber will address the consequences of imposing liability of Mr. Lubanga at this stage of the proceedings later in this summary. Finally, the appeals chamber rejects Mr. Lubanga's arguments regarding the standard of proximate cause and the but/for relationship as the applicable standard of causation between the crimes for which Mr. Lubanga was convicted and the harm suffered by victims. The appeals chamber considers that the third required element of an order for reparations under the statute is that it must specify and provide reasons for the type of reparations ordered, either collective, individual, or both, pursuant the Rules 97, para 1 and 98 of the Rules of Procedure and Evidence. The appeals chamber considers that the trial chamber ordered reparations only on a collective basis pursuant to Rule 98, para 3. Furthermore, the chamber considers that it was not an error not to award reparations on a collective and individual basis. In this respect, the appeals chamber notes that the number of victims is an important factor in determining that reparations on a collective basis are more appropriate than and that the trial chamber did consider this factor in arriving at its determination. The appeals chamber considers that when only collective reparations are awarded pursuant to Rule 98, para 3, a trial chamber is not required to rule on the merits of the individual requests for reparations. Rather, the appeals chamber holds that a determination that it is more appropriate to award collective reparations operates as a decision denying, as a category, reparations awards on an individual basis. The appeals chamber notes in this context, however, that a decision not to award reparations on an individual basis does not prejudice the individuals who filed individual reparations requests with respect to their eligibility to participate in any collective reparations program. Further, the appeals chamber notes that all of the individuals who filed individual reparations requests also submitted their views and proposals regarding potential awards and programs for collective reparations. Accordingly, the Appeals Chamber considers it appropriate to instruct the Trust Fund to take these submissions into account when designing the collective awards for reparations. With respect to the transfer to the Trust Fund of the individual reparations requests filed pursuant to Rule 94, the Appeals Chamber finds that the Trial Chamber's instructions in this regard are erroneous in that they do not respect the principle that the reparations are entirely voluntary, and also violates the victim's right not to have confidential personal information given to other entities without the informed consent of the victims having been obtained beforehand. Finally, the Appeals Chamber rejects Mr. Lubanga's arguments that the procedures of Rule 98 violate his right to challenge and make submissions in relation to the beneficiaries of an award for reparations. The Appeals Chamber amends the impugned decision to include the instruction that Mr. Lubanga shall have the opportunity to review the screening process of victims at the implementation stage, subject to any protective measures. Under the fourth element, the Appeals Chamber considers that there are two distinct aspects. One, identifying the harm caused to direct and indirect victims as a result of the crimes for which the person was convicted. And two, identifying the modalities of reparations. With respect to both of these aspects, Mr. Lubanga argues that the trial chamber erred in not making a determination itself in the impugned decision and instead delegated these determinations to the Trust Fund. The Appeals Chamber finds that both of these aspects must be determined by the trial chamber in the order for reparations. Thus, the Appeals Chamber agrees with Mr. Lubanga and finds that the trial chamber erred in delegating the task of identifying the harm caused to direct and indirect victims as a result of the crimes for which Mr. Lubanga was convicted. In so holding, however, the Appeals Chamber highlights the critical distinction between identifying the harms caused to direct and indirect victims as a result of the crimes for which the person was convicted, which must be done by the trial chamber, and assessing the extent of that harm for purposes of determining the nature and the size of reparations awards, which may be done by the Trust Fund once it is seized of an order for reparations. The trial chamber therefore amends the impugned decision by identifying the harms caused to direct and indirect victims as a result of the crimes for which Mr. Lubanga was convicted. In amending the impugned decision, the Appeals Chamber limits itself to the circumstances of this case where no additional findings relevant to harms for purposes of reparations were made by the trial chamber. Accordingly, the identified harms are limited to harms identified by the trial chamber in the context of the criminal proceedings against Mr. Lubanga. The Appeals Chamber has identified these harms by reviewing the relevant findings in the conviction decision, the sentencing decision, and decisions related to victim participation insofar as they relate to defining the harm caused to direct and indirect victims. As a result of this amendment and in the circumstances of this case, particularly in light of the findings of the sentencing decision, the Appeals Chamber considers that sexual and gender-based violence cannot be defined as a harm resulting from the crimes for which Mr. Lubanga was convicted. The Appeals Chamber therefore finds that the trial chamber erred in holding that reparations awards should be formulated and implemented to include victims of sexual and gender-based violence and amends the impugned decision in this respect. However, the Appeals Chamber considers that it is appropriate for the Board of Directors of the Trust Fund to consider in its discretion the possibility of including victims of sexual and gender-based violence in the assistance activities to be undertaken according to its mandate under Regulation 50A of the regulations of the Trust Fund for Victims. The Appeals Chamber further considers that it is also appropriate for the Trust Fund's draft implementation plan to include a referral process to other competent NGOs in the affected area that offers services to victims of sexual and gender-based violence. Regarding Mr. Lubanga's arguments relevant to the alleged delegation of identifying and appropriate modalities of reparations, the Appeals Chamber considers that Mr. Lubanga has misinterpreted the impugned decision. In the Appeals Chamber's view, the trial chamber did identify the appropriate modalities of reparations, based upon which the Trust Fund will design collective awards for reparations. However, the Appeals Chamber amends the impugned decision insofar as these determinations are not clear in the way they are presented in the impugned decision. Finally, the Appeals Chamber considers that the final required element of an order for reparations is that it must identify the victims eligible to benefit from the awards for reparations or set out the criteria of eligibility. In this regard, the trial chamber made these determinations in the impugned decision, which Mr. Lubanga challenges as being erroneous. With respect to inclusion of broader communities, the Appeals Chamber amends the impugned decision to clarify that only members of the community who qualify as a victim under Rule 85 may claim reparations against Mr. Lubanga. Regarding the inclusion of localities not mentioned in the conviction decision, the Appeals Chamber considers that the trial chamber did not intend to extend the scope of localities beyond those specifically mentioned either in the conviction decision or in the testimony of the witnesses listed in paragraph 915 of the conviction decision. The Appeals Chamber understands the statement regarding the inclusion of localities not mentioned in the conviction decision to refer to localities mentioned in the evidence of the witnesses who were relied upon for the conclusion in paragraph 915 of the conviction decision. Accordingly, the Appeals Chamber finds that the trial chamber did not err in this regard. With respect to matters relevant to the implementation stage, the Appeals Chamber finds that it is not an error for a newly composed chamber to oversee the implementation of the amended order for reparations and dismisses the parties' arguments in this regard. With respect to setting the amount of Mr. Lubanga's liability for reparations, the Appeals Chamber amends the impugned decision to exceptionally provide for this to be established by the newly composed chamber. This procedure is detailed in the judgment. In this respect, the appeals chamber wishes to stress the exceptional nature of this procedure and underscores that the imposition of liability on a convicted person, including the precise scope of that liability, should be done by the trial chamber in the order for reparations. This is particularly so in order to give effect to the right provided in the statute of the convicted person and victims to appeal an order for reparations. Accordingly, the appeals chamber holds that the trial chamber's determination of the amount of Mr. Lubanga's liability for the award for reparation constitutes a part of the order for reparations within the meaning of Article 75(2) of the statute and is therefore appealable by Mr. Lubanga and the victims pursuant to Article 82(4) of the statute. In sum, the appeals chamber amends the impugned decision and attaches to the judgment for purposes of clarity an amended order for reparations. In her dissent to the Lubanga conviction judgment, Judge Anita Uszadzka dissented with respect to the majority decision to confirm Mr. Lubanga's conviction and accordingly dissents with respect to this judgment. This concludes my summary of the judgment. It only remains for me to thank the parties and participants, the interpreters and the court reporters, as well as the registry staff for having facilitated this hearing. And not only this hearing, as in view of the fact that for four of us this will be the last hearing, I would like to thank my colleagues, the parties and participants, and all the staff for excellent cooperation and assistance all through these years. Thank you very much. The session is closed.
All rise, vous vous levez.